Hi, this is Anthony Brister, and this is a wealth planning podcast with Brister Law. Today, we're going to talk about estate planning, why you need an estate plan, and some of the basic documents that are necessary in an estate plan. There's only two things certain in life, and that's taxes and death. And that's why you really need an estate plan because no matter who you are, at some point, you are going to pass away. 67% of Americans don't have an estate plan. And what that means for them, when they pass away, the state decides how their assets are going to be passed. Now, I'm from Texas, and most of these documents we're going to be talking about today are going to be related how Texas law interprets it, but you can use a general idea in whichever state that you're in, and these same concepts should apply. So, what are some reasons to have a estate plan? Well, besides not having the state decide where your assets go, maybe you want to leave a legacy. Maybe you have kids and you want to decide who the guardian is, who's going to raise your kids if something happened to you. You want to decide how your assets are going to be distributed and have those go according to your wishes, who they are, who they're going to, when they're going to get it, and how much they're going to get it at certain times. Maybe you want to protect your assets. Maybe you want to avoid probate through using a revocable living trust. Maybe you have estate tax issues and you need to do some advanced estate planning. So let's get into the common estate planning documents. We've got wills, trust, power of attorneys, and a directive to physician. So a good estate plan has all of these documents. Maybe not every estate plan has a trust, but I do think that most people do need a trust, and we'll go in that in a little bit. Let's talk about a will first. So, what a will is, it's just a legal document that outlines how your assets are going to be distributed. You might have a provision in there about who your minor children's guardian will be if something happens to you. One thing about a will is if you have a will, you're going to go through probate. Probate is the court supervised process of transferring your assets and the title to your assets to your heirs after your death. Probate can be expensive. Typically, it's going to last somewhere between 6 months minimum to 2 years. I recently had a client come in the other day who's been through the probate process for 11 years now because of some land issues and disputes among the heirs. So, commonly you're looking 6 months to 2 years, but if there's any issues, it could be longer and it could be very costly. The next document we're going to talk about is a revocable living trust. I think 90% of people need a revocable living trust. And the reason why is that assets that you put in a revocable living trust avoids probate. Now, the trust does the same thing that a will does in that it distributes your assets to your heirs in the way that you want. However, when funded properly, and what funded means is titling assets in the name of the trust rather than in your personal name, those assets, when you pass away, or maybe when you become disabled, whatever provisions you put in there, those assets would go down to your heirs in the same way a will would distribute them. So you can have the same kind of distribution provisions. You can put a specified time period. Maybe a child is disabled or bad with money, and you want to only give them a certain amount of income each year, or you want to make a lump sum when they turn 30, 40, or 50. All those provisions you can put in the revocable living trust. Um, the trust is also a good tool because you're avoiding those attorney costs, the court costs, um, because you've already done the work to put all those assets in there. Another benefit of the revocable living trust is once you pass away, it becomes irrevocable. And depending on the provisions, you could have some creditor protections for your heirs if the assets remain in the trust. The next documents we're going to talk about are power of attorneys. And really, when I do an estate plan, I think of two that I use, and it's the medical power of attorney and then the statutory durable power of attorney. The medical power of attorney, it covers exactly what it sounds like. It covers medical decisions in the case of you are not able to make those decisions for yourself. Let's say you get in an accident, you're in surgery, and there's something that comes up, or maybe you've got dementia or Alzheimer's, and you're not in your sound mind. So the medical power of attorney, you get to choose if you're incapacitated in some way, who's going to make those decisions. I generally like to name at least two people, have your main person and an alternate. You can have co persons there if you want. The next document is the statutory durable power of attorney. And so this power of attorney covers financial and legal decisions if you're incapacitated. So who's going to pay your bills? If something legal comes up, who's going to sign on your behalf or, take care of those legal matters? Who's going to run your daily investments? If you're in a nursing home, who's going to pay for that? All of those things can be covered in the statutory durable power of attorney. The next document is the directive to physicians. I call this document the pull the plug document. Really, what it is, it works in tandem with the medical power of attorney, and it covers what you would want in the case of you're unable to make, the doctors think that you're unable to make a recovery, or it's unlikely that you would make a recovery. Let's say you're brain dead. Typically there's two options, whether they think that you have less than 6 months to live, but again, it's unlikely that you're going to recover, or you've got longer than 6 months to live, but they still think that it's unlikely for you to cover. And you can decide, how you want to be kept in that state, whether they want you, whether you want to be let go peacefully without any machinery or life-sustaining support, or if you want them to do everything possible and exhaust all measures before giving up. So that's a very quick one today. Again, just went over the basics of estate planning and those documents. Remember, every good estate plan needs at least a will. Maybe you have a revocable living trust. You're going to have a medical power of attorney and a statutory durable power of attorney, and then a directive to physician. Thank you for joining the Wealth Planning Podcast with Brister Law. Today was estate planning basics. Stay tuned for more discussions on how to build your wealth and create a legacy.